about jurisdiction, or cross-border issues. So, when we look, let's start with a sentence in the English language. Everything that we've been looking at, whilst we're studying the laws of Australia, or the laws of Victoria and the Commonwealth of Australia, the very nature of the internet, the very nature of technology is global. We spent quite a bit of time in the first intensive exploring this idea of the internet actually not being regulated. It might interest you to know that very early in the evolution of the internet, before Web 2.0, a number of developers would actually refer to the internet world or the virtual world on one hand, and what they referred to as the meat world on the other hand. I always like to say they're made of meat. And this idea that actually quite purposefully grew out of this is about technologies that interface with each other and communicating in a virtual world where there is no law, as opposed to the meat world where living, breathing human people need laws in order to survive. Now, the merging of the meat and the virtual world is all but complete these days. That there are very few of us who don't interact with technology every day in some way. And with the internet, the devices that are connected to the internet. And that is a global relationship. So there are a range of different types of international law that impact on what we're doing. And so I just want to provide a framework for us to think about jurisdiction. I want to do a very high-level run over what are now not new cases in relation to jurisdiction that pretty much summarise the position that we're at. So, a couple of different things. So, have we got any international law scholars here? Any of you spent any quality time with tequila? Different kind of tequila, I suspect. Okay, so, all right, in a nutshell, we have these two concepts. Firstly, of public international law. What do we think public international law might cover?
Human rights.
Human rights? Human rights, yeah, okay, good. What else? So, as a subcategory, what?
International treaties and obligations.
International treaties. So, public international law is essentially the law between nations, how nations work together or work against each other. So, yes, things like treaties, the kind of treaties we were talking about earlier to a large extent, the rules of war.
Maritime law.
Maritime law. Well, maritime law, is that a public international law or might that fit within the private international law sphere? Or both?
Both.
Both is a nice safe answer. Give me an example. So somebody want to have a guess at what private international law is, what we're really talking about there.
Between corporations.
Between corporations?
People, individuals.
Legal entities.
Cross-border transactions as much as anything else. Between individuals, laws as they affect individuals as opposed to nations or states. So maritime law is probably a good example of where there are some elements where we're talking about laws relating to the carriage of goods, for example. That falls squarely within the private international law sphere. Who owns a bit of the ocean floor? It's very much we're usually, what we're really talking about that is who gets the right to claim royalties or give people rights to dig oil out of an ocean floor, or which bits of it. That's a public international law question. So I'm thinking of the East Timor Sea at the moment. Binding international law.
Ratified treaties.
Ratified treaties? Is there such a thing as binding international law? Well, we look today at treaties that hadn't been ratified that are largely being followed nonetheless. Well,
No binding international law.
no binding international law. Just a,
It's all. I disagree because ratified treaty would be binding international law.
what happens
Well-
if you breach it?
Well, it's binding international law, but
What
there's
happens,
no.
for example, if you're a signature to a treaty that says that you won't lock people up without a charge, and then you just decide to put them, say, so because your laws locally say you can't do that too, you just decide to take some people you don't like and lock them up on an island somewhere. Just say somebody's going to do that. Would that be, like, just say you were, a signatory to a treaty that says you weren't allowed to do that? Would that be breaching an international law?
Technically, yes.
So,
Because
what
those
would
people-
this sanction be? I mean, well, what does binding mean then? Is there a
Depends what colour your
sanction?
skin is.
My skin is white, so I can do whatever I like.
So
Besides, there's no regulation.
So there's no regulation. Yeah, well, unless of course you send a bomb into Syria or somewhere, and then somebody's going to actually
there's
blow the
recourse to
projectile.
international criminal courts and international courts through the
I
UN.
must admit, this whole idea of this international criminal court, this is again why I don't teach international law and getting a high level view, but I used to always imagine Saddam Hussein at the shaving mirror, sort of, trimming his beard and thinking, gee, I better stay in that tunnel today, because otherwise I might end up in The Hague.
But that's where
No,
he ended up,
Belgium,
Kat.
where
He
there's
was
chocolate.
in a hole. Hiding from that
Like, it's
exact
so scary for me
But
to
didn't
leave this role, because I might go to a place with chocolate and waffles.
And the number of countries that have recently pulled out of that.
So I share Peter's cynicism, just in case you didn't pick that up. But yes, there is this concept of binding international law, so being the rules generally regarded and accepted as binding in relations between states and between nations, a framework for the practice of stable and organised international relations. Soft law, or soft international law. Sorry, customary norms. Yeah, exactly. So quasi-legal instruments which don't have any legally binding force, or whose binding force is somewhat weaker than the binding force of traditional law. And one might suggest that all of the domain name registration processes, the regulation of the way that domain names are allocated, recorded, and that the infrastructure around the way that IP addresses point to those domain names and how they're kept on the registries is essentially, it becomes soft law. There's no regulatory system that runs it, but these not-for-profit bodies make it work. So, in a sense, the things that I think you need to remember are that laws are national, but the internet is not. We talk about these different kinds of international law, but subject to Tequila telling you something completely different when you actually study this. Actually, he's leaving, you'll get somebody else. But telling you something different, I think we can all point to question marks over the way that international law works in some regard. The general concept that if the way that you want to resolve a dispute or prosecute a crime is to take somebody to court, the only way that you can do that is if that court believes it has jurisdiction. Now, as Gordon was saying earlier today, courts take a broad view as to when they have jurisdiction, and just because a contract says that a particular choice of law will be applied doesn't necessarily mean that the court will agree that it shouldn't be the one to apply those laws in a particular set of circumstances. When I, a million years ago, studied international law, pretty much most of what we studied was jurisdiction, because it's hard. It is hard to work out where jurisdiction is, why it matters, how to deal with it. And you've got these complex webs of different laws that might apply, particularly when matters happen in a third place or in a different place from that contemplated by the parties. It's got a whole lot harder since the internet came along. So what we're really talking about here is jurisdiction at the end of the day. We frame it as cross-border, but really what we're talking about is identifying what laws apply, if any law applies at all. So the kinds of concepts that we need to think about here are, in a commercial sense, governing law. So what am I talking about with governing law? So a contract will often state what law the parties have agreed governs the contract. So it's as simple as that. Contracts that are drafted by lawyers rarely omit some sort of governing law clause. Usually it will, a contract will at least have some sort of statement. It might be that it talks about exclusive jurisdiction or a non-exclusive jurisdiction, but it will point to the choice of law that the parties have agreed should govern their arrangement. Having said that, particularly with web contracts, they're not negotiated, so that doesn't matter, always. And then particularly with consumer contracts, there's another set of laws, notably in Australia, the Australian consumer law, but there are equivalents in the UK, in New Zealand, including in Singapore, and there are other national laws that will impact the subject matter of a contract as well. So even if my contract with my Alibaba vendor says that we're going to go to arbitration in Kazakhstan if my USB cable it doesn't work, if in fact my USB cable that they send me doesn't work and is dangerous, I might have redress under the ACL. I might have redress as a consequence of a breach of an electrical standard. My actual ability to pursue that and my actual interest in doing so are both quite low, but at least in theory those laws still apply because there's a transaction where the vendor knew that they were selling into Australia. The fact that they didn't know about the law doesn't help. So what's this idea of jurisdiction? So we talked about governing law and the contract. The jurisdiction itself, let's just be really clear on what jurisdiction is. It's like jurisprudence, but with a diction.
One of the aspects of that is if you have a disagreement, what jurisdiction are you going to have that arbitrate in? Like you said about Kazakhstan or usually Singapore?
So jurisdiction goes to what law applies, and sometimes, but not also always, where that matter will be heard. So you can have a clause or an agreement that says the laws of Victoria will apply and the parties submit to the non-exclusive jurisdiction of the Victorian courts. Which could mean that if in the end the subject matter of your fight happens to be something that somebody said about a goods you were going to deliver in New South Wales to a customer in New South Wales, and you get sued in New South Wales, because it's a non-exclusive jurisdiction clause, it is quite likely that the courts of New South Wales will hear that matter and make a decision based on the laws in Victoria, because it'll be Victorian jurisdiction. I'm completely oversimplifying. There would be days of argument and all sorts of things that you would deal with, but in theory at least, the courts of New South Wales, which is where the matter would be heard, could hear the law in relation to Victoria. And stretching that out, it might be at first instance a fight between me and my Alibaba vendor, which says that the laws of Kazakhstan apply. It may well be that the Court of Victoria will make a decision as to whether or not the laws of Kazakhstan can apply in relation to my contract or not, so at first instance. And you'll remember back in contract, we looked at a few cases like that where the question was initially, where is the contract made, so that we could work out whether or not the court had jurisdiction. So I'm thinking of the one, those who've done contract with me will not be at all surprised, I can't remember the case name, but the recently widowed Mrs. somebody or other went on a cruise in Greece. She got a ticket, and then she got some sort of order, and she took it to Greece, and when she arrived in Greece she exchanged the purchase order for a ticket, and the back of the ticket said, yeah, if you get hurt on the ship then the laws of Athens will apply. The ship sunk, or I don't know, something went badly wrong. She brought an action in, I'm thinking New South Wales, but it could have been Victoria, and they said, well, actually the contract was made here, so even, that clause, that was an add-on later on, and there was no choice of law clause. It's perfectly reasonable because she made a contract here for it to be governed by the laws of Victoria, and so we're just going to ignore that other clause about the laws of Greece. The other thing that's always relevant here is this enforcement of judgment. So my faulty USB stick that I've got from my AliExpress vendor, turns out that not only did it electrocute my small children, scare my puppy, but when I put it into my computer, it extracted all of my data and sent it to Kazakhstan, resulting, because I'm incredibly wealthy, as I keep reminding you, resulting in huge economic loss to me. So I've gone off to the court in Victoria. They've ignored that Kazakhstan thing. They've decided to award me, in my favour in this civil action. And then my next question is, how on earth do I enforce my judgment? Do I enforce it in Kazakhstan? Do I go to Guangzhou to try and enforce it there? Do I just get a new USB stick? Being incredibly wealthy, a couple of $1 billion doesn't really worry me, so probably a USB stick for me. Questions, concerns? Sorry, I'm trying to be amusing. It has been a long day and you guys are very quiet. You can tell me separately whether I'm achieving that or not. So ultimately, in a strict sense, jurisdiction is nothing more than the extent to which a court has authority to determine a matter. So it's more about its ability to determine than the location of a hearing. So John Pfeiffer, 2000 case, High Court case, held that questions of jurisdiction should be kept separate from questions of law to be applied by the court in hearing a matter. So if there is a question about whether a court has jurisdiction, that should be determined before the court then explores the question of law at hand. Make sense? Seems eminently fair to me. Enforcement is another issue that comes up quite a lot. So the question we have here is, how can judgments from other countries be enforced? Essentially, the foreign court needs to have exercised jurisdiction that our courts will recognise. So let's say in my Kazakhstan, Chinese, Melbourne-based example, I managed to somehow hack into the AliExpress process. I have taken this incredibly valuable USB stick and I have then reversed my payment and not paid for it. And so the AliExpress vendor has sued me in accordance with the laws of Kazakhstan, as expressed in the contract that we entered into, and sought judgment. In order for the sheriff to come knocking on my door, in order to get that $2.49 that I probably paid too much for that USB stick, what would need to happen is that order would need to go to probably at $2.49. I think it's probably the magistrate's court. Might be the federal magistrate's court though, I'm not sure because of the international jurisdiction. You can tell I'm not a litigator. But essentially it has to come to a court here, and a court here needs to essentially affirm that it will recognise the jurisdiction of Kazakhstan and recognise that order, and then the sheriff will come knocking on my door. The order itself, it'll need to see that the judgment itself is final and conclusive, and it must be for a fixed debt. Okay, so all pretty straightforward, but these things can get somewhat more complex. So let's just have a look at, this is an American case. There aren't that, the Gutnick case, which I've given you, is really one of the only cases, and sort of it's the B case in this area in relation to the internet. But let's just have a look. So Yahoo and LICRA. I'm saying LICRA because I have absolutely no French and I just don't want to have a go. Problem is, LICRA makes me think of middle-aged men on Saturday mornings at coffee shops, but and it's not a good thought. These guys, this particular LICRA group were...
How about LICRA? How about LICRA? How about that?
LICRA, maybe. Anyway, they basically were... I'll see if my notes actually describe them, I'm not sure. Anyway, basically, they were a group of people who were focused on ensuring that the Nazis did not regain power. And they had very successfully campaigned for laws in France that prohibited any kind of, I'm lacking words today, aggrandizement of the Nazi regime. So, amongst other things, these rules prohibited the sale for profit of Nazi propaganda. So Yahoo, in fact, this is how old this case is, it's a Yahoo case. So do I have sorry, let me see if I've got a date for it. No, can't see it. So Yahoo basically had an online memorabilia auction site. This is pre-eBay. And French people could use that list to buy this propaganda. And so LICRA said, well, actually that's a breach of French laws. You can't do that. It breaches the French criminal code. And Yahoo said, well, actually, everything that we do happens in the USA. That's where our servers are, the laws governing our contracts are there. Yes, we can see that French people can access our site, but it would be really, really damn expensive for us to change that. And that's actually not our problem. It's not illegal to sell this stuff in the States. So we're not doing the wrong thing. So what kind of issues come up there from a jurisdiction point of view?
Whatever we advise.
Which law applies? So how does that come up? So what are you seeing? What are you thinking?
A transaction happened in France.
Did it happen in France?
Was it based on a transaction in France?
Well, there's a purchaser in France,
Yeah.
and there's a vendor somewhere else. The vendor is outside.
The vendor sells into France.
Vendor is selling into France. They're auctioning goods.
Where is the money being transferred?
So a vendor, so a price has been agreed over an auction site. I don't know enough about how, this is pre-eBay, so I don't know enough about how that auction site, but it's on a list, there's been a negotiation, a contract has been made over the internet.
The problem that makes it unclear is that one party is operating with one jurisdiction, the other party is operating within the laws of another jurisdiction, and it's which law applies.
So if you were Yahoo, what would you argue?
You would argue because it's outside of business efficacy to change their whole site to restrict French people from buying Nazi memorabilia.
Also, yeah, how do you even do that? Because if you look at like
geo-block pages.
yeah, but if you look at like RMIT emails that come from rmit.edu.au, half of them come from Australia and half of them come from the US, which is obviously where different parts of the servers are.
Yeah, I'm constantly in St Kilda Road.
Yeah, well,
Marcus,
Isn't this the same with like things that are legal in one country and illegal in another? Like if someone in America sends a stun gun over here, customs will not going to give them a fine. So is this part of the question? Like
who's committing a crime here?
It's the
If
French
it's
version.
is it not similar in some ways to those cases, or what I call the inducement cases, like
the
Partridge and
invitation to
Crittenden and those kind of things? It's like, well, am I actually committing a crime? It's not a crime where I am to sell this thing to you. Your
But it's
criminal
a crime
here
to
is your
purchase.
purchaser. So actually, should you be going to the purchaser? But of course, LICRA is not the. They're not.
No.
They're not arguing that they're not trying to enforce the French criminal code. They're actually a lobby group saying you need to stop doing this because it is a breach. Sorry, Mark.
Doesn't it turn on where the contract was made? So the server hosting Yahoo put the offer to the world, and that was accepted on their server, although it might have been from France. Isn't that where the contract is formed?
Maybe Australian law would say, possibly, in fact, I think Australian law would say it's an invitation to treat.
Yeah.
And so it's an invitation to treat that originates in Australia, it sits wherever it sits, and the contract is formed when it's accepted. So the contract is made in France. So using that logic, if the French law says that it is a crime to offer Nazi propaganda for sale, or to make it available in any means, then an Australian may be subject to that jurisdiction. But that's Australian law. This is, here we're talking about US law and French law.
So
I'm just trying to tease out what the issues are so you
So
can
where
pick
is the
my
contract
points.
then formed in this situation? Is if the server and the offer all comes from the US, and someone in France reads it on a screen and clicks yes, it's still processed in the United States, isn't it? Isn't that where the server is domiciled, where the transaction is held? So it's a vision from France of a computer server where the offer,
And these are exactly the
whole
kinds of
right
issues that a
capacity.
court needs to think about. Is the contract made with the act of I accept, or is the contract made at the moment that those little zeros and ones hit the server?
Correct.
Because if we work on our old school thinking about contract, acceptance, the contract is made at the point that acceptance is communicated.
Correct.
So communicating being what the listener does, that's the point at which it's heard.
There are also capacity to contract issues, like do I have the ability to contract in France? Like, you know what I mean? Was the person in the majority or the minority who was making the contract? There's a bunch of issues that probably could be teased.
And I mean, this is an American case. Well, it's actually a French case involving an American company. So it's of limited value to us from a contract precedent point of view. Where it's valuable to us in this environment is to recognise the complexity of the issues. And also, I think, for those of you who are going to be commercial lawyers, to recognise too that when issues like this arise, when there isn't clarity, then a judge is going to have to make a decision. And with the greatest respect to many judges, there are many others of them that have got no idea how email works. Like they will still print. Some of you will work with lawyers who have emails printed out for them. Those people become judges, right? There are plenty of judges who know less about technology than we do. And so the whole enterprise of actually getting this problem solved requires probably a barrister, there's the humour in it all, explaining to a judge how this technology works and pushing an argument like Mark's that actually it's made at the point it's made back in Australia, in the US, or it's made in France, or whatever you're arguing, because these things ultimately turn on the facts at the end of the day.
similar to tax issues.
Similar to tax issues, in the sense that the arguments just get quite silly.
Where's the taxpayer?
Where's the tax payer?
So
Yeah.
the ATO is going after, say, tax from Yahoo on a transaction that happened in America, but they're saying, well, the good land's in Australia, yet we want to do this tax. Yeah, but that's a tax that levied when it crosses the border and enters the jurisdiction, so it's levied then. Yeah, but I'm just saying, like, online is in its infancy, whereas other jurisdictions have probably got more case law that could be applicable. Look, US methodology. Law is always in favour of the stronger party that's making money and disregards the weaker party.
Everything we need to know about US law in one go. Kat, you've got to come back to you, Jack.
To the criminal code in that the crime occurs at the point in which the information is downloaded, or the jurisdiction in which it is downloaded. So similar to Mark, at the point when you hit I accept in France, then that therefore is when the act is occurring. create a contract.
So that helps in relation to saying, okay, let's assume that that's all true and is probably likely, would make sense. It's much easier for France to enforce its laws within its borders. That's great in basically being able to send around the guys with the guns to the person who hit, I accept, and bought the propaganda or the memorabilia. It seems like an odd thing, Nazi memorabilia. It just feels wrong. But anyway, that aside, that's fine. Here what we're doing is trying to extend this to the provider of the internet services that allow that to happen. So the case, I think, is useful more from the conversation than it is from the outcome, really.
So what was the outcome?
Oh, let's move through. Ultimately, the outcome was that, the outcome ultimately is America. Well, the thing is, ultimately, Yahoo wasn't successful, but there wasn't really anything that happened as a consequence. So it's more about a story than it is about an actual outcome. The outcome was business as usual. But anyway, these are kind of arguments that we have. See, and I love it. There's always a First Amendment argument in the States. I'm thinking, if it's so important to them, why did they actually not have it in there in the first place? Why is it an amendment? But anyway, I don't know. So we've talked about those arguments. So at the first instance, essentially what the court said is, actually, this is all too hard for us. We need to get some independent experts to tell us if this really is as hard as Yahoo was saying that it is to do that. But we think there are sufficient links with France to mean that actually if you're going to run a business here and you're going to take money ultimately from our advertisers generated because people are in France are using this system, then actually you should comply with our laws. Just because you're not physically here, you're virtually here, you need to comply with our laws. They found that Yahoo was aware that French residents used the auction site, and it displayed French language advertisements on its pages if people from France accessed the site. So it wasn't a surprise to them. The court specifically dismissed the claim that the alleged problems of enforcing a judgment was sufficient to nullify its competence. Said, okay, just because it's hard to enforce doesn't mean that we don't have the right to make that judgment. So, which I do think is interesting. So then on appeal, Yahoo said, well, we actually can't comply with that. So only about 70% of our French internet users could be identified by the use of DNS databases, but the court found that Yahoo did need to comply with the original injunction within 3 months or face a 100,000 franc fine. So then it all moved to California. So Yahoo didn't appeal the second time in France. It just thought, yes, this isn't going well for us. We might just go back to California and see what happens there. So they asked the US District Court in San Jose to find that the French ordinance wasn't effective. So Judge Jeremy Fogel found that the decision returned by the tribunal in Paris was inconsistent with the First Amendment of the Constitution, and it impacted a freedom of expression, and consequently it's inapplicable in the United States. Really interesting to have a look at that when we think about what's happened in the world since and what happens in relation particularly to anti-terrorism. So if you're allowed to express your opinion as long as the government agrees with it, perhaps. So
does that mean that if that was to happen, you would go to your home court, get them to agree with you, and then if France, in that case, tries to have their judgment,
and it says, well, actually this isn't something that...
point guns at Yahoo and take money out of their bank account, the US would just turn around and say no. And so
well, let's go. It did get appealed. So the French government... So the Ninth Circuit essentially reversed that, found that the District Court didn't have personal jurisdiction over the appellants, and it quoted the following criteria for the establishment of personal jurisdiction. So basically it said actually you need to have a minimum contact. US law doesn't apply in France. If American companies are going to transact in other places, then they need to be ready, willing and able to comply with the laws in those other places. So, here's the words. The non-resident defendant has purposefully directed his activities or consummated some transaction with the forum or a resident by which he purposefully availed himself of the privileges of conducting activities in the forum, thereby invoking the benefits and protections of its laws. So if you're going to seek the law, be protected by the laws of France, then you need to comply with the laws of France. So a much more sensible outcome than, yeah, we think you should be able to say and sell anything you like anywhere, if it's expressing your freedom. So what's the last bit there? The requirement is satisfied when the defendant is alleged to have engaged in wrongful conduct, targeted a plaintiff whom the defendant knows to be a resident of the forum state. So the majority conclusion was the district court did not properly exercise personal jurisdiction. So more recently, and at home, is a Joseph Gutnick case. Does everybody know who Joseph Gutnick is?
Diamond Joe.
Diamond Joe, exactly. Sorry, I'm just assuming, maybe not everybody does. So Joseph Gutnick is a rabbi. He comes from a family, a large Jewish family who are of Orthodox persuasion, but I think it was their father had a vision that a member of his family would find diamonds in the desert of Australia. So both Joe Gutnick and his sister Penina have had various mining enterprises looking for diamonds over the last 30 years in Australia.
Did they find any diamonds?
Yeah, I think they have found diamonds. I don't think quite as many as the vision might have. Vision might have been in HD, but they're a very wealthy family. Very philanthropic family, but very controversial family in many ways.
Yeah, he came from the Rebbe Schneerson in Brooklyn, who had these visions that he would fax people.
Yeah. Oh, it wasn't his father, it was the rabbi in New York, was it?
Rebbe Schneerson in Brooklyn faxed his father.
I didn't realise it was that technology. I think if I had a vision, that affected somebody, I'd probably feel the need to
Fax them.
maybe not fax. Maybe, I don't know.
Tweet them.
Tweet it. I would tweet a vision. It's
It's a little while ago.
But very controversial family in a whole heap of ways, and very much associated with the specky mining Western Australian stock. So an online newsletter published by Dow Jones called Barron's had an article called Unholy Gains, which Rabbi Gutnick thought was defamatory of him and put him and his family and his business interests in a bad light. So what did it do? It states that some of his business dealings with religious charities raise uncomfortable questions. Then uses some language, this is from the Judgement, some language that the media have appropriated from the law courts, implying that a balanced trial with equal opportunity to participate by all has been taken place. That a Barron's investigation found that several charities traded heavily in stocks promoted by Gutnick. The article associates the respondent with Mr. I can't say that name, Goldberg, who is apparently a convicted tax evader and another person awaiting trial for stock manipulation in New York. So, things that do not look good for Rabbi Gutnick's financial relationships. So, basically these were published online in the States. Apparently 16 or so, 5, I went with 16. 5 copies of the print edition were actually put on a boat to come to Australia, but as these things happen from time to time, they got lost. So there's no evidence that any print version ever arrived in Australia. Gutnick therefore resorted to the internet-based publication in order to show an actionable tort in the jurisdiction, so the tort of defamation. The internet version of the magazine had 550,000 international subscribers, about 1,700 of them had Australian-based credit cards. So 1,700 people maximum might have read this. A lot more did because this action was brought. So Jeffrey Robertson, I'm sure we're all fans, argued for the publisher as to whether it was considered published from where it was uploaded in New Jersey, or published into where it was downloaded in Victoria. And the argument was on publication and jurisdiction. Actually, is this a case you do in tort?
Yes.
Yeah.
Okay, so you know more about it than I do.
That,
Definitely. Thank you.
not at all.
So what was the issue here? What's the jurisdiction issue? I'm not interested in the defamation issue. Well, I am, but not for these purposes at this time of day.
Which law applied?
Which law applies? So what do we think which law applies?
I know the answer.
You know the answer.
Yeah.
Well, that's a good thing, isn't it? We can move faster.
Victoria-
So it never dawned on me that you would have done it in torts. I'm not quite sure why.
Victorian law applied.
Why?
Because that's where it was downloaded, and that's where it was. The Australian law, well, Victorian law of defamation is where it's transmitted.
Yeah.
Where that
So
defamation.
as soon as the third party reads
Yeah.
it, communication is what the listener does.
Yeah, that's it.
So if people wish to do business in, or indeed travel to, or live in, or utilise the infrastructure of different countries, then they need to comply with the laws of those places. Interestingly, the author of the article, not Dow Jones, but the actual journalist, applied to the UN to appeal and was ultimately settled with a payout to Gutnick for an undisclosed amount. So, we do have some legislation that helps us in Victoria and in Australia generally. So the this is actually Commonwealth, the Foreign Judgments Act, so judgments from superior courts and some inferior courts from 36 different jurisdictions are clearly registered. So interestingly, the US isn't one of those places. Court needs to be satisfied that there would be a substantial reciprocity, I can never say that word, of treatment of Australian residents. Sorry, I'm going to skip through the contract law stuff because we've just spent enough time there. So, the last thing to consider here, and actually I think I will probably wrap it up here, is we do have international treaties again that impact the way that this works. I've purposely put this little map on the side. It's a little bit hard to see. The purple bits are the countries that have ratified the Hague Convention on the Choice of Courts Agreement. So, in theory, this was something that was going to make it a lot easier. So the agreement applies to the choice of courts and the recognition of resulting judgments. Parties under the convention recognise a choice of court agreement between parties, and then if a court isn't chosen, then they essentially say, go away, your agreement falls under this convention or this agreement. It says law of Kazakhstan applies. Off you go and have it heard out there. You can't come to us. We're not going to backle about that. But as you can see, we're basically talking about the EU and Mexico. So we've got, well, Denmark's not in there. We've got Singapore, the Ukraine and the United States have both signed the convention, but neither have ratified. Okay. So, look, there are more slides there to have a look. I'm not as interested here. What's not important to you for what you're doing is what the outcomes of these things are, but being able to recognise where the issue comes up and what kind of problems arise and where the complexity arises. I think that's what's interesting to us and what you might find relevant for exploring. You all look exhausted. I feel exhausted. Any closing questions, observations, frustrations?
No way Trump will ratify that.
But he might build a wall. It'll be a big wall.
Huge wall.
Huge wall.
Tremendous hanger.
I was just going to say, obviously, there are mentions about arbitration awards and decisions that also reflect some of that.
Yes.
But people are happier to sign up for that.
Yeah, it's interesting actually. Again, not a disputes lawyer, so I do tend to gloss over some of this stuff in that context. But yeah, I think countries are happier to sign up to arbitration, and I know my clients will want arbitration before they go to a court because they think it's a more manageable process.
Well,
I'm not
just
sure
based
that's
on
always
what,
true, but I think
the gentleman said this morning that most of these, the LICRA and the RAP cases arose through sort of arbitration clauses or some sort of that sort of.
well, there needs to be
enforcement
there needs to be
thing.
something that people want to fight over.
Yeah.
I mean, just the very nature of a dispute means there needs to be a clause, something contentious in there, something that somebody doesn't want to comply with.
Yeah, but the fact that they're happier to like go, hey, we'll recognise your arbitration awards rather than your courts.
Yeah.
It's an interesting point.
Absolutely. Okay, guys. So 10:30 tomorrow morning. I think at 11 we've got AUDA. Tomorrow I want to focus on data protection, cybersecurity, and privacy. In a broad sense. So data protection and cybercrime effectively. So having thrown more privacy in if there's not enough. There's never enough privacy, really, is there? Okay, have a good night, people. Thank you.